Mhm.
Okay. Hi, everybody. This is Dan from Liberty Bell. We're going to start our training for the night. If you have a question or you need to ask me a question, just type in the chat box. Hopefully, you're able to find that, and we'll be able to, open up so that everybody can ask me questions if they want. So the training tonight is on estates. I'm not going to cover everything from a legal point of view, even though some of it may be from a legal point of view. But what I am going to cover is from a real estate sales point of view. So this happens to everybody at some point. Somebody gets a call and says, my dad or my mom died or my aunt died or my cousin died or so-and-so died and we have to sell the house. And a lot of agents have no idea what to do at that point. Or they get bad information from somebody else. So we're going to start kind of at the beginning, assuming that you got a call like that. Somebody calls you and says, hey, my dad died and we got to sell the house. So when I get that call, now remember, I always say you have to be asking questions. What's that? Hello? I can't hear you. Why don't we mute everybody, Scott? I didn't hear a word you said if you were talking to me. I wish I could do it. How can I do it? Okay. So let's just start at the beginning. Somebody calls you and says, my dad died, my mom died, we have to sell the house. So what I was saying is you have to be in control of the situation. The person in control of the situation is the one asking all the questions. So a lot of times it's good if you want to ask the questions, but you need to know what questions to ask. So keep in mind also that this training is recorded. So you can always visit our back office website and you'll be able to see this training. The number one issue is for us as an agent is the person that we're talking to legally authorized to be able to sign a listing contract with us? That's what I need to know. So somebody calls me and says they want to list their house for sale. I got to make sure that they're the right person, that they're allowed to do that. So when they call me and say that their mom died, my first question is was your mom married? If she was married, is her husband alive? Because if her husband's alive, then technically he could probably be the owner of the property. And this goes back to how title is taken and what's the chain of beneficiaries in an estate. But if two people take title to a property as husband and wife, that means when the husband dies, all of the property goes 100% to the wife and vice versa. So if two people are married, even if they're not living together, if they're married and one of them dies and they owned a house together as husband and wife and there's no divorce proceedings, technically the other spouse owns 100% of the house. Now, we've been involved in some very crazy situations where there's multiple people that, this isn't for one of those situations. This is more of a standard what happens in a normal basis. If you have a crazy situation, you got to call me and talk about it, and maybe we have to get an attorney involved. So my question is was your mother married? If she was married and the father is deceased also, that's fine. We just need proof that he was deceased. So we need a death certificate for him and for the mom. Was there a will? That's a question that you have to ask. Why is it important to know if there was a will? And most of us should have heard the term testate and intestate. So one of the ways is you die with a will. One of the ways is you die without a will. If you die with a will, one of the main ingredients in a will is the person who made the will decides who is going to be in control of the estate. And they name somebody to be an executor or executrix, an administrator or administratrix, or a co-administrator or a co-executor or co-executrix. And that person is named in the will, and then there's a backup person that's also named in the will. So why do I need the will? Well, the title company, we don't necessarily need the will, but the will needs to be probated at the township, and it becomes a part of the file for the property. So the title company is going to do a search on the property. They're going to pull a copy of the will. So we're going to get it anyway. But we might as well get a copy of it now, because in the will it names who the person is that would be authorized to sell the property. So if there's a will, then we know who's named in that will as the administrator or executor or executrix of the estate. That person is the person that we need that has control. That's the person that can sign a listing contract. That's the person that can execute an agreement of sale. That's the person that we really need to be in touch with. If that's not the person that you're talking to on the phone when you're talking about the listing, you need to stop talking to the person that you're talking to and talk to that person. Because remember, you can have a great rapport with somebody. That doesn't mean you're going to get the listing. If somebody else is in control of the listing, they're going to control who gets the listing or who they hire to sell the property. So that's why I want a copy of the will. Okay, now there is something called a short certificate. So I don't know if any of you have ever seen this. Hold on. Here it is right here. So this person died with a will. And their daughter was named the executrix. You see that right there? So when somebody has a will, they name somebody as the executor or executrix. When somebody doesn't have a will, typically they become something called an administrator. All right? But let's just talk about the situation where there's a will. Where there's a will, the person that died named somebody to be their executrix. This person named this, so this woman that died named this person here, Christine, as the executrix. Now, here's what happened. This was a Philadelphia property, and you could see their certificate of grant letter. This is called letters testamentary. So this person, Christine, hired an attorney. The attorney went down to City Hall and the Register of Wills office. They brought a copy of the will. They brought a copy of the death certificate. They brought Christine. They brought her ID. And they said, we want to become legally named the executrix of the estate. And then they go through there's a little process they go through down there. What they really want is money. You have to pay money to the Register of Wills in order to file for an estate. And then the person swears on a Bible, or they say this affidavit that basically says they're going to do everything correct and legal according to the estate. Then a few days later, they get this thing in the mail, this letter. This right here is proof that Christine is authorized to sell the house, or to handle the estate, or to list the property, or to sign an agreement of sale. So the title company is not going to let the deed to the property get transferred unless they have a copy of this letter from the township. And so we shouldn't, when we're listing a property, we should ask for this. And if they don't have this, technically they're not authorized. Now, if you look at the will, and the will said, so if Christine showed me the will, and the will had her authorized, and I knew her to be Christine, I could assume that she's going to get this at some point, and maybe we would list the property. But ultimately, she can't sell the property without having this paper. So you guys hopefully all follow that. And some of this, you may be, doing this for the first time. You'll get me involved, and I'll help you. But you want to know that we need this form that names them as the authorized party. Okay, then what if they die without a will? Well, if they die without a will, they get something else. They get something called letters of administration. See, this is different. This says letters of administration. Remember that other one said, what did it say? Letters testamentary. Letters of administration is when somebody dies without a will. Believe it or not, though, this person died with a will, but it's a long story. But I'm just going to let you know that part right there. This person right here was named the administrator of the estate. This is the person that was deceased. How do you get determined to be the administrator of the estate if there's no will? So when somebody dies and there's no will, technically everything in their estate goes to their next of kin. So if they die and they're married, everything they have goes to their husband or wife. Now, if there was a previous marriage and the property was bought prior to that person getting married, and there's other variables involved, yes, it could be different. But in most cases, if somebody dies, everything that they own goes to their next of kin. If they were married and their spouse is alive, everything goes to their spouse automatically. And when there's a transfer, or a spouse inherits everything from their deceased spouse, there is no transfer tax. So, what if their spouse is dead? So now somebody dies, they don't have a will, their spouse is already dead. Their estate automatically goes to their next of kin. Their next of kin would be their children. If there's no children, their next of kin would be their brothers or sisters. If there's no brothers or sisters, their next of kin would be their nieces and nephews, or it could there could be it could be grandchildren. But if they don't have any children, maybe they do have a grandchild. But again, we're getting into situations that wouldn't normally happen. What normally happens is somebody dies and there's either children or there's brothers or sisters. Anyway, you would go, now the question becomes, what if there's multiple brothers or sisters? In this case, there was 4 brothers and sisters. Now, the brothers and sisters signed something called a renunciation letter that gave this person authority to become the administrator. And I just did it on another sale. Hold on. Oh, watch, I don't have it. That would be a shame. Sorry for the delay. I wanted to show you this. This is something. This is something called letters of renunciation, I think it's called. Nope, I don't have it. It's funny. I do have it in front of me on my desk. This doesn't help us, but I'm gonna get copies of it. Hold on. This is kind of important, and I wanted you to see this because somebody else come. I'm sorry. This is kind of important because I wanted you to see this happens a lot. Somebody dies and then they say, there's 3 children and there's no will. Well, one of the children needs to be named administrator, or all of them need to be named administrator. In the event that all of them would need to be named the administrator, they all would have to go down to the township. So in this situation, I have a guy calls me up, says my dad died, he wants to sell the house. Okay. Is there any siblings? I say to Charles, or no, his name's his name is Charles too. The son is Charles. Charles, do you have any siblings? Yes, I have a brother and my sister. My sister died. Okay. Did your sister have any children? Yes, she had 2 children. Okay. I need a letter of renunciation for both children and for your brother. So guess what he did? He got this letter of renunciation. You see this? It says, this is the name of the estate. I, Adam Smith, blah, blah, blah. I renounce my right to administer the estate. And I request that letters be issued to Charles West, Jr. Signed and notarized. Guess what? The other son, Zachary, signed the same thing. Request letters to be issued to Charles. And then the brother, John West, signed the same letter. So now, I keep missing these. Sorry. So now, we go to court, we go to Register of Wills downtown, we give them these renunciation forms plus the death certificates. Everybody knows what a death certificate looks like? This is a death certificate. It needs to be clear. You need to see the person's name, their date of birth, date of death, Social Security number. There's another one. Kind of harder to make out. So now this guy Charles, he can legally. So he left. I just had that. We went to court. They charged him $400 to set up the estate. And then a week later, they sent him this form. Look, his dad did not have a will. He got letters of administration granted to him. There you go. The estate of Charles West Sr., letters of administration to Charles West Jr. Now I know I got the right guy. That guy can sign the listing contract. He could sign the agreement of sale. And the title company will allow him to sign the deed to transfer the property. Now we could sell the property. If he didn't have this, he can't sell the property. Even though he might be the right guy and they did those letters of renunciation, it would be irrelevant. He couldn't sign over the deed. The title company won't insure it. So hopefully you get a sense of now, we go back to these questions. Was your relative married? Is their spouse alive? If they were married and the spouse was deceased, was it a second marriage? Is there a will? Can you give me a copy? How many children were there? If there's no will, the children, we need all the children to be involved. We need death certificates. If they were married, we need their death certificate and their spouse's death certificate. Are there other assets? This is an important question to ask. If there were a lot of other assets, and they need to file something called an inheritance tax return, guess what? They should probably get an attorney. And you need to be able to recommend an attorney to them. So how do you find an attorney? Now, I would have one that I would recommend. Oh, sorry. So this is look at this. By the way, this is accurate. These people, this is a multi-generational law firm. They were established in 1893. Anyway, I know that the person I dealt with is not there anymore because he's got sick. But this law firm they've been there for a long time, and they handle estate law. So you could recommend them, or you could recommend other law firms, but at some point you may need some of their questions may be beyond the scope of what you're able to tell them. You can always call me, but it can't hurt you to say, you know what, this is something I would recommend you speaking to an attorney. How do attorneys charge for estates? A lot of times they're like real estate professionals. They might charge like a flat fee or like a percentage of the value of the estate, or there may be some minimum. Typically, here's what's going to happen. They have to schedule an appointment to go down to court. Attorneys are usually going to charge $500 or $600 to do that, plus there's a filing fee. In this last situation, the filing fee was $400. So the attorney's probably going to charge $1,000 to go down to court. Then they may have to attend settlement. They may have to file and prepare a inheritance tax return. So a typical estate might cost a couple grand to handle. If the person doesn't have the money, this guy didn't have the money. Now, this was somebody that was referred to me, and I knew him personally, or I knew the other person personally that referred him to me. I gave him the money. It cost $400. I had to give him the $400 because he didn't have it. So it depends on the type of situation that you're in. I wouldn't recommend giving somebody the money. He signed an agreement with me before I gave him the money, but at this point, if you're dealing with somebody in these situations, you may advise them to get an attorney. Once you find out if there's other assets in the estate, you know this. Now this is not applicable in New Jersey. In New Jersey, there's no estate tax. In PA, there is though. But in New Jersey, you have to be authorized to sell the property too. But the estate tax in PA is, if a child is inheriting something from a parent, it's 4.5%. If it's a brother, sister, aunt, uncle, it could be up to 14%, the inheritance tax. So why is it important to know this? Because inheritance tax, look at this, is a lienable item. It's just like real estate taxes. So when a title company is transferring the property from the estate into the new buyer's name, they're going to need to make sure that the inheritance taxes are paid. So what if they're not paid? This just happened this week with another sale that we have. The person sold the house for around $100,000. It was a sibling, so it was 14.5%. So the title company wanted to hold $40,000 because they were inheriting $14,000. They were inheriting around $100,000. The real tax would have been $14,000 or $15,000, and they wanted to hold 1.5 times that tax. So they wanted to know that the tax was there plus 1.5 times that amount. Now, if you have a sale going on, it's important for you to know that this stuff could come up. Again, if you're uncertain about these types of questions, you got to call me. You can't be steering the seller in a certain direction without knowing for certain what's going on. So how does a title company determine that the tax is paid? Well, check this out. This was one of my items up here. If I could find it. By the way, just so you know, look at this letter. This woman died in December, I think. Wait, I might have her death certificate. Oh. Excuse me. Did I lose everybody? I hope not. Wow, so look at this. She died May 5th, 2010. All right? May 5th, 2010. So about 7 or 8 months, 8 or 9 months after she wrote this. So look what she wrote on August 20th. She wrote this letter. My will. My house goes to my 4 kids. Right? I want my 3 older kids to let Vincent stay in the house till he finds a place of his own. This is very important, by the way. Most of you probably don't think that this is a legitimate will, but it is. And it held up in court. And these kids got into a fight with each other, and over this line right here, I want my 3 older kids to let Vincent stay in the house till he finds a place of his own. By the way, does everybody know how long that could be? Forever. That's what the judge said. Until he finds a place of his own could be forever. What the mom's intention here was that he should be able to live here until he didn't need to anymore. Look what she wrote. Missy gets my car. And Vincent, when you sell the house, give Missy $500. Do you hear me? She did everything for me. And to my 16 grandkids, 13 great-grandkids, she wrote this thing, and she signed it. And somebody signed as a witness. See that? This is a real will. Anyway, that was a distraction. I wanted to show you that. There's this thing as a receipt. So look at this. Pennsylvania inheritance tax receipt. Total amount paid, $2,700. This is just a receipt that says that they made a payment. It doesn't mean that that there's no taxes owed. And I'm going to show you this. So what the title company is looking for is this form in Pennsylvania. Notice of inheritance tax appraisement, allowance or disallowance of deductions and assessment of tax. Look what it says down here. Total due, 0. When the title company gets this letter, that's evidence to them that the inheritance tax is paid, there's no more money owed, and nobody can come after them. So they feel that at this point, their obligation to protect the interest of the buyer is now met. and that there's not going to be any inheritance tax owed. When we give the title company this letter, then they'll release any of the money in escrow. Guess what? To get this letter, could take 6 months. So we could send in the payment and we can get this receipt, but to get this letter could take a long time. And there might be a way to expedite it, and of course if you had an attorney it might be expedited that way. But look at this too. It says here, tax return was accepted as filed. So the title company needs to see this in order to release the escrow. God has a deal right now. Today he went to closing. They're holding a lot of money in escrow for inheritance tax. Title company is not going to release that inheritance tax until they get this. Now what they did say is whatever tax was due, the original payment, they would cut a check out of the escrow money for the payment, but it would be made payable to the Register of Wills right here. Okay. So that's one of the questions that you need to ask the person that's selling the house. Did you already file an inheritance tax return? Sometimes people do, and I wanted to show you. Here's an inheritance tax return. My computer's slow, Scott, because too many windows open. That was a joke. All right, so here's an inheritance tax return. I don't know what that was. So they filled this out. They put all their numbers in. They followed the instructions. They needed to pay $27.68, and the title company wrote a check, or they needed to pay a little bit more. They needed to pay $29.48, and the title company wrote a check made payable to the Register of Wills, and we mailed the check with this return. If you go to the state website for these returns, there's also instructions on how to fill it out. And you could give this stuff to people, but you can't act as an attorney. So a lot of times you could direct them on how to handle it or what to do, but your best advice is usually to say you should get an attorney. So did you file an inheritance tax return? What is letters of renunciation? We covered that. Inheritance tax is a lienable. I don't know. Is there a problem? Does somebody need me to help them? I did record a message stated wait until leader comes to conference. Okay. All right. All right. So we covered the renunciation letters. We covered the lienable. That the inheritance tax is lienable. This causes a big problem in all these sales, by the way. Everybody is totally caught off guard by this. So it would be better to discuss this at the time that you're taking the listing than 2 or 3 days prior to settlement, or when you get the title report. How does the tax get paid? I just showed you. So there's a receipt. Oh, by the way, here's the instructions. You can Google this. Instructions for Form Revenue 1500. I showed you the receipt. There it is, right there. And it goes to the Register of Wills. That's how the tax gets paid. But how we determine that there's no tax due is different. That's that notice of appraisement form. How does somebody become authorized to handle the sale? I talked to you about that. The becoming named the administrator or the administratrix. You guys saw that. One other thing that comes up, when somebody's selling a house and it's an estate, person's deceased, the money gets made payable to the estate, not to the person. So Charles West, that guy that I just showed you about, he's not getting the money. Where's he at? This guy. The check is going to be made payable to the estate of Charles West Sr. then Charles West Jr. needs to take that check, go to the bank, and open up an estate account. And then if there's a will, the person's supposed to follow the instructions in the will and deliver the money to wherever it's supposed to go. If there's no will, technically, there was 3 siblings. Each sibling gets a third of the estate. So whatever's left, each sibling gets 1/3. The children, the sister died. The sister had 2 children. So 1/3 would go to Charles West Jr., 1/3 would go to John West Jr., and 1/3 would get split between the 2 kids. That's technically the way it's supposed to go. Now, is there somebody that's going to? We don't care. So it's not like somebody's going to tell us, we just want to complete the sale. The check gets made payable to the estate, and Charles West Jr. takes the check. He could do whatever he wants at that point. Nobody can come after us beyond that.
Dan, there's a question.
Okay, hold on. But if the kids are on the deed, then they don't have to do this, correct? With no will. All right, that's a pretty good question. And that's it. Who is that? Steph. Hi, Steph. Okay. I was just making sure that it wasn't somebody that I already dealt with this with. So if the kids are on the deed with the parents, it depends on how the deed is structured, which I just did this with somebody else. One of these, look, this guy. This guy died. I mean, his mom died, Ruth. Ruth was married to Joseph. Joseph died 10, 15, 20 years ago. She just died in August of last year. She was on the deed with her 2 children, and somebody advised them to create a life estate. So the 2 children were on the deed with the mom, and the kids thought that they didn't have to pay inheritance tax because they were on the deed. But they did. They ended up having to pay inheritance tax on half of the property. She owned half and they owned half. So it is that could be a complicated situation. So if you had somebody that said, when you say to them, when they say, my mom died, if there's other people on the deed, then that means the estate is an owner and then the children are owners. And it really becomes complicated. And at that point, I'd really advise them you should get a lawyer, because the answer to your question is technically no. They would still need to get, somebody would still need to be named the executor or executor or administrator if they didn't have a will, and they would still have to pay inheritance tax. These guys paid inheritance tax. If the property was in a trust, that might be different. There might be different rules. If you get into a situation like that, you should call me and we'll talk about it, and you should really be advising them to get an attorney. That's probably the best answer. You can't go wrong with that answer. All right, so you know who the I like that. What do you need to do if you're on the buyer side? What you need to do if you're on the buyer side is you need to make sure that you order a title company. You do not, for any reason, want to use the seller's attorney or a seller's title company. You want to use a separate third-party title company. And what you want to do is get a copy of the title. And then for the buyer, there's no difference. They're buying a property, and they're going to settlement. They're getting title insurance on the property, and there's really nothing for them to do. The title company and the real estate brokerages need to handle the estate. So as a buyer side, it's a typical transaction, or it can be a typical transaction. The only problem is person signing the deed would be the administrator or executor for the estate. All right, so this was just an overview. I wanted to give you some of the terms. I wanted to get you the ability to look at some of these forms, the death certificates, the short certificates. I wanted you to see that will, the letters of administration. Of course, if you get involved in a situation like this, like an estate, I would help you. But I also don't want you to seem like you don't know what you're talking about. When you have somebody that says there's an estate, you need to make sure the most important thing is that we have the right person that can sign a listing contract and can sign an agreement of sale. And that contract and the agreement of sale can be valid. If the wrong person signs those forms, they're not valid. So if you list the property with the brother and I list the property with the administrator, I don't care who the administrator is. The administrator could be the priest that was related to it could be no relation to the family. But if they have this form that says they're the administrator, and I list the property with them, and you list the property with the son or the daughter or the aunt or the uncle, I got the listing, not you. So we need to make sure that we know we got the right person. That's most important. The rest of it we can always work out. Is there any other questions? Or does anybody have anything that they want to add or that they're concerned about or something they feel like I didn't cover? All right, again, you guys can this is recorded, so you can see this on our website. And if you have any questions, you can always call me directly. Call me on my cell phone or call me in the office, and I'd be happy to go over this stuff with you. I hope you guys learned something. I'm sure you did. And again, if you need anything, let me know. All right, thanks for coming to the training again.